Hey guys, and welcome to the weekly docket. Hey guys, good evening for the intrepid viewers who are here on the short notice evening weekend weekly docket. We did the surprise stream this week of Megan's case, so that put me off getting this ready in time. But still, there's a few interesting things to go over. And before we watch some crime shows, we'll go over what's actually happening here with your drink of choice. So let's see what we got. All right, let's start out with Richard Allen because, man, this case has got some wild stuff going on behind the scenes. And hello to Virginia, from Virginia, myself originally. Allen, of course, is accused of murdering Liberty German and Abigail Williams. Evidence is basically of his own testimony that he was on a bridge around that time, and then an unspent round was found at the scene that they believe is tied to his handgun. I think that's all the evidence I know about anyway. His similarity to the sketches are there, but then so are a lot of people. So some people see the case as solid, some people see it as weak, and we don't know much more about it because a lot of it has been under seal. So the judge says that she will unseal many of the documents next week. Okay, so prepare for a lot of sensational commenting on that and then finding out what actually, if anything, is material in it. I mean, I really hope that they solve this case. So I hope they have the right guy, because if he's not, it's terrible. He's in jail. And if it is the right guy, I hope they bring this case to the right conclusion, because that was an awful set of murders, just absolutely awful. Trial date is set for January of 2024. And let's move to the next item here. Now, a motion to file, our motion was filed to exclude ballistics evidence. And that's got to be about the spent round, because I don't think there's any indication that anybody was shot. And a lot of people on social media are complaining about this kind of evidence, this tool mark evidence, which is also how they analyze spent rounds. But tool mark analysis is when you take something and compare it to something else and say, hey, this tool made these marks. That could be from a screwdriver. That could be from the operation of a firearm on the shell casing. It could also be on the projectile. As it's going down the barrel, it's marked by the barrel. That's tool marking. And it's not straightforward science in the sense, say, that DNA is, where you put these things in the computer and it comes up with a probability, and people like that, which I do too. This is somebody who's trained looking at, say, one shell casing, comparing it to another, and deciding that they're similar enough, and saying to, my belief, this came from this handgun. These two came from the same handgun. So some people say, no, it's junk science, bro. You can't have it. And I don't know that it's junk science, but I get that it is subjective. However, that type of testimony is allowed in court all over the place. I've shown a lot of examples of it in other cases, and it's allowed in the state where this is. So I don't see the judge excluding it at this point, because you haven't even heard from the expert witness to know the quality of the testimony. That being said, I don't blame them for filing the motion, because without that spent round, as far as we know, the case is substantially weaker, right? And whether that round makes it a lot stronger or not is subject to debate, but it's an important piece of evidence. As far as we know, it's the only physical evidence, I think. All right, so that's not going to be ruled on yet. All right, and so as I say, I think it'd be unlikely to be granted. I'm trying to read the small font. Sorry about that. Yeah, somebody says that's the only quote unquote real evidence. And maybe I think that, it's kind of a good way to put it, because I can't pick him out on the video as being that guy, right? I can't. And I'm not going to say he's not that guy, even though, I get these weird comments saying that it's proven that it's not him and stuff. I tell you, the videos I made on this case have generated the strangest comments of any case that I've been involved in. That the videos are made up, the family did it, and it gets worse from there. So that's kind of why I haven't made another separate video on this case yet. I don't want to until something really solid comes up, because then you're just dealing with some unhinged lunatics telling you they know things that they don't know. But going back to your comment here, it's the only real evidence. Yeah, I think, in terms of physical evidence, because he's put at the scene around the time by his own testimony. And yeah, sometimes criminals do that, and sometimes innocent people do that. So that's not enough by itself. And you have the analysis of the timing chain of events that doesn't look good for him, and some testimony about his car and blah, 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 and all that stuff. So he was there around the time. Doesn't mean that he was the only person who was there. And it doesn't mean that he did it. None of that alone means that. But if people are convinced, if a jury's convinced that that's his round there, I don't think the Eagle of Innocence defense will work, that round was picked up and brought there by the girls or dropped there by something else. I think that's real trouble for him, and that's why they would file this motion at this point. Having said that, I don't know whether the comparison is weak or strong. I will say it says it's from extraction markings, and that's going to be on the weaker side of it, because if they had a spent projectile, that would be the best thing probably you would want to match up for it. Because it gets all the tool marks going down the barrel, and those are visible to the naked eye, much less going through a microscope. And you can get ejector markings and magazine markings and other things. The extractor is just a little hook that catches on the shell casing and pulls it out of the chamber, and then the ejector flips it out. So there could be more marks on it than just the extractor, but that's what the probable cause affidavit said. So you were talking about a small piece of evidence, a small piece. Well, that's interesting. I don't know about that. If I'm catching what you're talking about there, I don't know if they have any evidence from his phone one way or the other, for or against him. I'm not aware of it anyway. So let me make this bigger because I'm trying to read it while I'm talking to you, and it's pretty tough. So maybe you can't read it either. So I also had a lot of comments which were reasonable, which were, hey, they found the shell casing on the ground. Why isn't his fingerprint on it if he did it? Or, whoever left it there. What about DNA? If you don't have the DNA and the fingerprint, then that's bad, which I agree. And then some people take it more than that and say, if you don't have those things, it just means the police put it there and it's a total frame up against him. And that's just not true. It's not true at all. And I cited in earlier studies how hard it is to get DNA or even fingerprints off of shell casings because of the way the metal's made for those things. And so I thought I'd throw this in here because I saw it today. This is from the New Mexico DA in the Alec Baldwin case. And they were questioned there by the defense saying, well, why didn't you get the shell casings tested for fingerprints and stuff to see who loaded the gun or whatever, where it came from and stuff. And they said, look, they won't even do DNA testing, the FBI. And I think it says they don't like to do fingerprint testing either because you get so few results from it. So it's interesting. You would think that you're pressing down on the shell to load it into the magazine, it would leave DNA. I would think that as a layperson, but when I read into it, I found out it's often, the majority of the time, not the case. So, they find a shell casing on the ground and it doesn't have that evidence on it. It just is how it is. It doesn't, in my opinion, go for or against them in that regard. So I have not heard about this. So if I do hear about it, I'll certainly want to follow back up on it, but I'm not aware of it. So that would be interesting. Certainly. I mean, he was there pretty close to the time, whether he was there at the time of the abduction, which is really what this case is about, is what this is all about. So we haven't got to the explosive part yet, but let's get there. Now, remember, he's not charged with the actual murdering of the girls at the scene. He's charged with felony murder, which means that the killing, you were engaged in another felony and it was connected to the killing. So it's the kidnapping, really, taking them off of the bridge. And if they can prove that he's the person who did that, they get felony murder, which is just as good as murder for their purposes. So they were in court arguing about his custody location. They had him in this supermax prison and all this stuff. And as much as I'm pretty confident they got the right guy, but have an open mind to some degree about it, I don't think that's appropriate. I agree with the defense on that. That's too much for somebody who's trying to defend themselves in court, who's not engaging in violent activity in the jail. It makes it almost impossible for him to participate in his defense. Now, the sheriff said, I don't want him, court, but if you order me to take him, then I will. And that's your job, sheriff. So I think, in my opinion, the sheriff should do that, and the court should order it. And I'm not soft on crime or this guy either. But if you prejudge the situation to say, well, I think he's guilty, so let's go ahead and make his life as miserable as possible and deprive him of the opportunity to have a reasonable defense and participate in it, what's the point of the trial? So I think you just gotta deal with it. You need a fair trial for the guy. Having said all that, look at this bottom paragraph here. Confessed, So apparently during this hearing, the DA said that Richard Allen has made incriminating statements, basically confessed a half dozen times to multiple people. Now, sometimes that comes up and you have the jailhouse snitch and you don't know whether the person really told the jailhouse snitch that or not. What's interesting about this apparently is the defense was not denying it in court. Okay, so that means they're not saying, hey, this is just a jailhouse snitch who's lying. Richard Allen never said it. What they said is, his reduced mental condition is why he's saying things and he doesn't really mean them. Now, I don't have a transcript from that or audio from it, so I'm going off secondhand reporting. But what is very unusual about this is for the defense to argue that it's the mental condition resulting in these confessions to other people and not that he didn't say it at all. Because if you go around telling people you did it, that isn't good for you. And this could, it could possibly come out in court, right? So that's a big problem for them, and I'm sure they do want to get him out of there. Now, of course, if you have seen him, boy, does he look like a different person. And if he's faking any of it, he's not faking all of it. He looks completely different, and he's totally out of it as he appears in court. So I don't know if some of that's put on or not put on, but he's definitely had a life-changing experience so far. So again, he has apparently said 5 or 6 times to more than one person, admitted his involvement in the killings of these girls. That's what the DA said, and the defense apparently was not contradicting that, but rather saying those statements were the result of his reduced mental capacity. And I wonder how long they've known this, because, when they filed this motion to get him out of the Supermax place or whatever where he's at now, they were talking about how his mental state was deteriorating. I wonder if they knew then that he'd already told somebody, look, I was involved in this, and they needed to start prepping it up saying he's already gone crazy, so don't pay any attention to that. We'll have to see what happens with that. If the guy did it and he is having trouble holding that back and it's driving him crazy and he's terrified because he thinks they're going to get him, well, that is what it is. But if he is crazy, you don't want him blamed for something he didn't do. So I do hope they move him. So that's weird. I also saw that there was an intern from the defense office that talked about how terrible it was to get to him and stuff, and how hard it was and stuff. But I didn't hear that he confessed to the intern. I'm not saying you're wrong. It's just I don't know many of the details on this. But it wouldn't surprise me also that if they said that he didn't recognize the intern and stuff because he's going loopy or whatever. So sometimes people confess to things that they didn't do. That does happen. So you have to be sensitive to that. But when the DA says they're saying it in jail and the defense attorneys are going, yeah, they are saying he is saying it, but it's because he's crazy. That is a step different than what you normally see. Say the Zachariah Anderson case where the DA said that he had confessed things to other people in jail, and the defense said he didn't say that stuff. And that's normally how it is, because a lot of these people are motivated to lie about the confessions so they can get special treatment and stuff. So it's whether they're lying or not, it's good to impeach their credibility. So that's a pretty big deal there. It's the biggest thing I've heard in all this. And then when they deseal or unseal documents next week, that'll open the throttle up on people commenting about this case, whether there's anything right to say about it or not. And I absolutely agree with this. Without a video from the courtroom, you just don't quite exactly know what was said in there and how it was said and stuff. But that's why I want to put all the provisos. Yeah, no, I think that's true too. He is a lot thinner and leaner. And I don't know if he's deemed competent or incompetent or undergoing any kind of exam. I just know that the defense is saying that, he's gone loopy. So, and his appearance supports that. Whether it's true or not, I don't know. But, physically, he doesn't look like he did when he got there or anything like it. Yeah, this is rough. And to my mind, unless you're posing a danger to other people right then and there, they can do this a little differently than that because the guy has a trial coming up. Anyway, we'll see. So sometimes people confess because they're guilty, and sometimes they wrongfully confess. So you just can't be for sure here what's going on with this. So let's slip it out to Idaho here to our buddy Bryan Kohberger. I talked about this a little bit on Eric Unleashed channel earlier today with Andrew Burkhart, who has attended some of the hearings live, which is a great way to do it because you get the flavor for the whole room and the dynamics between people and stuff that's not on camera. Anyway, a couple of things on that, because we have talked enough about the non-dissemination / gag order until the judge does what we all knew the judge would do eventually, which is amend it and keep it in place, but with some changes to it. So I just thought this was interesting, and I'm not trying to dunk on the defense here, but the state makes a request for discovery just like the defense does. And one of the things they can request under the law is notice of alibi defense. So if you're going to claim an alibi, you're going to say, well, I wasn't in Idaho that night. I was in Nebraska, and here's my hotel receipt and a video of me hanging out at Red Lobster. So I couldn't have been at the scene of the crime. That's an alibi. And the state's entitled to know about that. So what the defense is saying here is, we can't tell you that alibi right now. We're going through all the discovery. You've given us 10 jillion gigabytes of data, and we're looking through it and all that. And let's oversimplify it for a second here and say, if you have a real alibi, i.e. you knew you were somewhere else, you weren't at the crime scene, you know that already. Why can't you just say that? Why can't you say, my alibi is I was sitting at home and I was watching this movie, or I was at a friend's house or whatever? Like, why do you have to look through all the discovery the state has when you know when the crimes occurred before you can tell your alleged alibi? So it's not that simple, though. It's responsible of the defense, if they can, to avoid telling us right now and to get all the information from the state they can before they play their card. You want their information before you give up your information. So I get that. I'm not dunking on them too hard. But on the other hand, if he had an ironclad alibi, I don't think you'd have to wait to say it. He also wants to slow this case down a little bit so they can attack the indictment. So they'd ask for transcripts and other things like that, and some things the state's not consenting to, so the judge is going to have to rule on it. And the defense is saying by the time we get all that to attack the indictment, we'll be coming in on the eve of trial. So they're asking for the case to be stayed until this happens. And that's an interesting play to do, I think, because in theory, you'd want the case fast if you could, if you were him and you thought you were going to be found not guilty at trial. And attacking the indictment, maybe there'll be some technicalities or whatever, but if this is the guy who did it and killed 4 people, you're not going to walk away free because of some issue with an indictment. It's just, I don't think that's going to happen. So, but it's a potential death penalty case. They're going to fight every angle they can, and they're going to fight this one. And it'll be on technical things. It will not be on whether there was enough to indict him, because proving something in a court of law beyond a reasonable doubt is one thing. And you may think they're heading there with Kohberger like I do, or you may think I don't know yet, or you may think they're not going to make it. That's okay. But getting an indictment is a substantially lower bar. And they had obviously enough information to indict this guy. So on the factual quality of the indictment, I don't think there is an argument. So this will just be all technical lawyering stuff, I think. So, well, if we're talking about, let me see, if we moved on to the Kohberger in the comment section here, why is it so complicated? Well, one thing here is they have a potential death penalty on the table at this case. I mean, they kind of do in the other one too, but you will often see a lot of motion practice, and that's what's going on here by defense attorney Taylor, who was maligned in the media like she was some kind of fraudster or grifter or whatever, and that's absolutely untrue. I mean, I'm no defense attorney because I don't want to be one, but she has handled herself professionally, and she hasn't done anything wrong, and she should put the state to the test on the areas where she thinks that makes legal sense to do. That's her job. That's what she's supposed to do. So she's doing it. So I haven't seen her do anything bad, in my opinion. Now, I don't know if they haven't declared yet, I think, whether they're for sure going to go for the death penalty or not. They have a period of time where they do that, and I don't think they've reached that yet. But I think there is a family wanting to do it. And if you can do it, and the state's already got these death penalty attorneys going, why wouldn't you do it? It's the leverage you have on him if he did it, right? If you ever want him to plead the case, if something happens where you feel like you don't want to pursue it all the way to the end, and if you don't have the death penalty to give up, then you're not going to let him out again if he killed 4 people. So life is all you got left. And I don't think that's it. So basically, well, let me put it this way. I think there's some weird law out there or whatever that if he doesn't say anything, then there's no way the state could argue that he accepted the indictment. I think his attorney cleared that up, that even though they think he could have stood and said not guilty or innocent or whatever they want him to say, that there was some potential that he might be deemed to have accepted the indictment by answering that. So they let him stand silent, even though they didn't think that would be the case. So I don't draw anything from the fact that he stood silent compared to saying anything, but I think that was why they did that, was because they were going to attack the indictment. So I think you're right there. This attorney is appointed and paid by the state. And she's actually from another county because there aren't but so many death penalty case qualified attorneys floating around that area. And that was part of the attack on her, was the county where he's being tried had to reach an agreement to pay an hourly rate for her because she's a public defender of another county. People saw that rate and thought, oh my God, she's ripping the government off. And, you know, you look at the top line rate, but you don't read the rest of the contract of what expenses are included in that, including staff and stuff. And no, she's not ripping them off on her rate, at least. You know, hours is always a potential different story, but this is going to be her practice, right? This is her case for now. And she deserves it. And he deserves it. He deserves a competent attorney who's qualified for this kind of case. We can't say he did it until he goes through the trial. So he should have that, because this is pretty serious, because whoever did this is a terrible person and should get the death penalty. They're trying to bring back the firing squad or whatever, but although I don't think that'll ever happen. We talk about that some other time, but for that person, they certainly deserve it. You know, I think we're about to leave him, but I'll make one other comment about that. You know, they've talked about how his parents were called for a grand jury back in Pennsylvania and other things, looking for crimes and stuff. I don't think they've connected him to this stuff, but I can tell you, in the old days when I was involved on the other side, not the defense side, but the other side, and trying to work on these cases, these kind of cases, it was fairly typical that somebody who would either enter somebody's house to assault them or to murder them, but often, you know, I'm talking to the kind of assault that I'm talking about, they would do other types of crimes first, like a peeping Tom stuff or whatever, and scope things out. And the bravery increases on what they want to do, as well as the fulfillment of the fantasies they have. It's less satisfying as they say do the peeping Tom a couple times. You know, that's pretty exciting at first, but it's not really what they're after. And they want to act out this horrible scene that they have in their head, and eventually they do the crime. So if he did it or whoever else did it, I would be surprised if they had not done other crimes first, either entering people's houses or peeping and stuff like that. Whether you ever connect that with him or, you know, whoever, I don't know, but you know, it's reasonable to think that's the case. It would be unlikely that this would be just the first crime he ever commits, other than maybe speeding, or I think he had a seatbelt violation. And we're jealous because we're sitting here in Woke County and we're not at the beach right now, but we share your humidity, if not humility. So let's all do a dunk together this evening on Lori Vallow situation for her motion for new trial. We talked about that in terms of the media. Oh my God, a juror gave an interview and now she's going to go free. And then we looked at the law and we're like, it's not going to happen. And it was denied. As you can see, defendant's motion for a new trial is denied. All right. You know, I wish I had a co-host sometimes because I could drink some while I'm doing this. It makes it tough. Let's go into the poll vault and look at the poll we did on remote witnesses. And I did the poll on it because it just became kind of a hot topic. And it's a little bit interesting to me to see how people feel like court should operate, like what's equitable and fair. And there's what the law is, and there's what people feel is equitable and fair. And you want those to join up at some point. So it's interesting to see sometimes if they're the same or they diverge. So the question was, should adult witnesses who claim they are victims be allowed to testify over defense objection remotely? And you can see 15% of the people said yes, a victim shouldn't have to appear in court if they don't want. 15% of the people. And some of those are going to be from the UK because they have some rules over there that allow for that. I think they've moved that into place for domestic violence victims and stuff like that. They won't be questioned by the abuser, or maybe not even in the presence. I don't know all the rules they have over there, but probably some Americans too coming in on that. But that's a minority of the people who think that it's just the victim's election to not appear in the court if they don't want to. That's the minority. And I don't share that opinion. Now, the second largest group was 30%, which is no, in-person testimony is important to a fair trial, and there are no exceptions there. If I had to pick between those two, then I certainly would pick this one. I cheated a little bit and down at the bottom. Thank you for this. I might do that in a second. I cheated a little bit with this bottom one that says, yes, if judges find defense is harassing the witness. Because the answer is typically that they won't become remote, but the judge does have a solution there. We'll go over that a little bit. And it is not the case that somebody just has to sit there and take it from somebody who's abusing them. So really the question for remoteness is the victim's election. Can the victim just say, I don't want to be in court in front of this person, just let me do it remote? And the answer in the U.S. is no, that's not how it works. And I agree with that. Now, if they come to court and the defendant is doing something bad, the judge has some power there. So first, who's zooming who? Not, and this is some copy stuff from the last one. Sorry about that, but this is what we were discussing then. Not all remote viewing is the same. So I ruled out doing it from home like I'm doing right now, because at any moment this thunderstorm that's passing by could cut this off. I'm not hooked up to a phone, but it sure seems like a lot of people who zoom into court are, and their batteries are at 2%. You can see this picture down at the bottom right of when the lawyer called in and somehow had a cat filter on and was assuring the judge that he wasn't a cat. And I wouldn't know if that got turned on, how to turn it off any more than that poor guy did. I think somebody who was decades younger finally came in and turned him back into a human. So my view is remote testimony, and the way we discussed it is in the context of a controlled environment, not people sitting at their home or driving a car while they're smoking and stuff like that, which you see all of that if you tune into any of these live streams at court that are doing those right now. People just do whatever they want. So the default state of the law is live testimony. And some of the comments that came in on the poll, we're talking about civil cases. Hey man, what happened? I've seen, testimony used in other cases and stuff like that. So that's a really good point, but a lot of those were civil cases. The Sixth Amendment applies to criminal cases, and that's the one that says you have the right to confront the witnesses that are against you. Okay. That's in criminal cases. That's not for civil cases. But even for civil cases, the default state is live testimony. Now, for civil cases, there are procedures to secure testimony that's out of court. Usually you can get depositions out of state and things like that. And it's not as tight as it is for criminal cases. Also, if the parties agree and the judge decides to allow it, then somebody can be remote. And that's what's going on in the Peterson case down in Florida, where the defendant agreed that the state could call a witness remotely. I didn't see this one, but I absolutely believe it. I did, when I was trying to find the Brooks stream the other day, I tuned into one of the other courts first, and a lady was asking the court, I guess, about coming in paying her fine. She's like, are you open on weekends? And the guy's like, are you kidding me? The judge said that. He was trying to help her, and then she got the message, though, and she reversed the curse and got cooperative, and it worked out for her. So she was one of the better ones, I think. So in criminal cases, you can see non-live testimony. There can be prior testimony if the case was kind of the same or was the same and there was cross-examination potential and stuff like that. You sometimes will see that. Or here's the catch-22 that I'm sure it comes up in law schools all the time. If I kill the person and they can't come to court to testify against me because I murdered them, then if they said things to other people, can those people come into court and say that like he's about to kill me kind of thing? And I say, no, Your Honor, they can't come in and say I was about to kill that person because I killed that person and I'm entitled to question that person. There are some exceptions for that, and it gets stupid and weird because it's all controlled by lawyers, and it's whether it's testimonial or non-testimonial. Look at there, we got a fellow Wake County practitioner here who runs a fantastic channel. So the court says if you were saying things in a non-testimonial way, then it can come in because you really weren't trying to be a witness against the person. So if you tell your neighbor down the street, I think he's going to kill me, he's probably going to kill me any day, that might be considered just sharing your feelings. And so it could come in, But if you told the police officer, if anything happens to me, this dude is the one who did it, that could be considered testimonial and held out. That's exactly what was going on in the Mark Jensen case in Wisconsin. You also might have an ongoing emergency, like that guy just shot me and he's in that building over there. Well, maybe that can come in. So, there are some exceptions there. Now, there is an exception for children. The Supreme Court has recognized that there can be some protections for children in a case, criminal case, that they may be screened from the defendant sometimes or in a different room with counsel from both sides, some stuff like that. So that's, I think, the only exception I really know about for that sort of thing. But the court has authority over the proceedings, right? So if the defendant is doing something whack, then the court can terminate cross-examination if they think it's done. The defendant can forfeit the right to be there, like Darrell Brooks did. She kicked him out of the courtroom and muted him sometimes. So assuming the defendant has a lawyer and the defendant is doing horrible things while the person's on the stand, the defendant may be kicked out, but the person stays in the room and continues the testimony. So that it's not like the court just has to sit there and let it happen. That is absolutely not the case. All right. So that's why I say option C was a little bit of a trick, because courts do have authority to control the witness exams if abuse is occurring. And sometimes courts have forced, like here's a concept, the person's pro se and the judge can say, well, I'm not going to let you ask any more questions to this person. If you want to continue cross-examination, I'm going to say you have to have counsel do it, or you can just not do it because of your prior behavior. So you have to show that they did something to cause that. Yeah, I got a good one here. I'm not going to slam this drink down till this is over. Talking about that she knows what's up upstairs. I think she's downstairs. So my opinion is witnesses need to come to court and testify. That's the way it ought to be, and that's the way that it is. And it can be hard and it can be uncomfortable, and I get all that, but you're talking about the government putting somebody in jail. So I sound kind of like a defense attorney right now, but I think it's important to have these protections. Now, the UK, as I said earlier, they have some different ideas on that, and that's okay too. There's no holy writ that there's only one right way for everybody to think. And I think it's just fine for the UK and the United States to be a little bit different, because isn't that the whole point of why we're different countries? At least that was the story we told everybody. For example, in the UK, they can give a negative inference if somebody doesn't testify in a criminal case, the defendant, I mean. And in the United States, you cannot do that. So we have some more defense protections than they do over there. It's a major point of the Constitution and Bill of Rights was to enshrine individual rights and protections against the government. So, all right. There is a case going to the Supreme Court where I mentioned it last week, where there was video testimony due to COVID and health concerns. Not that the person was terrified of the defendant, but just health reasons. And they're appealing that, saying that they should have come to court and testified, not been on Zoom. So I do kind of hope the court takes that up, because technology's here, and it wouldn't hurt to have some guidance on, are courts allowed to do this, and what are the parameters to bring people in remote? I think it would be cool to do that, but not from your house on Zoom. It's not formal. So even if the court were to find it appropriate to have a pandemic exemption or some other new exception to face-to-face confrontation, I think it's going to be very limited. All right, and here's where I was dunking on people who talked about just having people zoom in on stuff. Why have anybody there? Just do everything on Zoom. So, yeah, to the degree it's accurate. I'm a little out of my realm here because I'm mostly a civil guy. And here in Woke County, we recently transitioned to electronic filing of lawsuits. So that was interesting for me the first time that I did it. It's just weird not to go to the courthouse and do it. Of course, when I worked at a big firm, someone else would go do it, would actually take it over there. But still, there's a formality to go into the clerk's office. In the old days, they'd stamp that puppy in, and it's just cool. And now you do it all online right here at this desk. So whatever on that. And time marches on. So my ideas of, everybody has to come to court for stuff. Younger people may feel differently about that. Yeah, I think if I'm catching this comment right, that the court can have a breakout room or something like that, and the people could be brought in and stuff. I got that. All right, so it was all Zooming. and all live streaming all week long with the case of the young lady who poured lye on her father and then took off to the party and called back to try and get his credit card number and was frustrated she couldn't. And then it got really inconvenient for her because she got arrested. And then it got super duper inconvenient because she got convicted. And now she has the sentencing phase coming up next month because her father died a horrible death due to the lye being poured over him. So that case set a record, I think, for some kind of homicide style case of any that I've seen, because it got done in 1 week and sometimes only going half a day. So that was crazy. Yeah, all this patient record stuff is crazy. Does it really save time, or do you just spend more time on the phone arguing with your clients as they try to access portal? Who knows? And if your server goes down, it's a bad day. So I'm not seeing too many questions, which is good. And I'm hoping everybody is having a good evening and will have a good weekend. And thanks for tuning into this puppy. We've got some big stuff coming up on cases pretty soon. We're just a little bit of a lull here. And that's it. And everybody have a good night. Thanks. Bye.